Buying the wrong thing can turn into a serious problem fast. You might think, it's not a gun, it's just a crossbow. And under federal law, that difference usually matters. Crossbow is generally not treated as a firearm because it does not fire a projectile by explosive force. So the federal felon in possession firearm ban usually does not automatically ban crossbows. But that does not mean every person with a felony can safely buy one, keep one at home, carry one in a vehicle, or hunt with one. The real answer depends on federal law, state law, supervision rules, hunting rules, and your own paperwork. The biggest danger is not always the crossbow itself. It is the rule you did not know applied to you. Federal law bars many people with felony-level convictions from possessing firearms or ammunition, according to the ATF's Prohibited Persons Guidance. But federal law does not treat every weapon the same way. A firearm is generally a weapon that expels a projectile by the action of an explosive, under 18 U.S. Code Section 921. A gun uses explosive force. A crossbow uses stored mechanical force to launch a bolt or arrow. That difference matters. Because of that, a crossbow usually falls outside the federal firearm definition. So, under the federal firearm rule, a person with a felony is usually not banned from owning a crossbow in the same way they are banned from owning a gun or ammunition. But this is where people get in trouble. Not a firearm under federal law does not mean legal for you. It only means one federal firearm rule may not be the rule that stops you. State law can still restrict crossbows. Local rules can still matter. Court orders can still apply. And supervision conditions can be stricter than ordinary law. So federal law is only the first layer. The answer depends heavily on where you live. States can write their own weapon laws. Some states treat crossbows mostly as hunting equipment. Others may regulate them as dangerous weapons in certain situations. Some may have rules about carrying them in vehicles, storing them, using them in city limits, or possessing weapons after certain convictions. So a crossbow might be simple to buy in one state and legally risky in another. Keeping a crossbow locked at home may be treated differently than driving around with one in your car. Target practice on private property may be treated differently than carrying it through a public area. Hunting on private land may be treated differently than hunting on public land. Local rules can matter too, especially inside city limits. But if you are on probation, parole, or supervised release, slow down. This is often the biggest danger zone. Supervision conditions can be stricter than regular ownership laws. They may say no firearms. They may say no dangerous weapons. They may mention hunting weapons, knives, bows, ammunition, or anything that could be used as a weapon. Federal supervision rules can restrict access to firearms, ammunition, destructive devices, or dangerous weapons as described by the U.S. Court's Supervision Conditions Guidance. A crossbow may create a problem even if it is not a firearm. For example, keeping a crossbow in your bedroom while on probation could be viewed as weapon possession. Riding in a truck with someone else's crossbow could raise questions. Going hunting while your paperwork says no weapons could become a violation. Do not rely on a friend, a store employee, or a comment online. Read your paperwork. Look for words like weapons, dangerous weapons, firearms, ammunition, hunting, bows, or access to weapons. Then ask your supervising officer or attorney directly. If possible, get the answer in writing. Being allowed to hunt with a crossbow is not the same as being personally allowed to possess one. States often set detailed crossbow hunting rules. They may control seasons, licenses, tags, age limits, training, equipment standards, and where crossbows can be used. For example, New York has specific rules for hunting with a crossbow. But hunting legality and felony restrictions are separate questions. A state might allow crossbow hunting during certain seasons. That does not mean your court order allows you to possess one. A wildlife agency might issue a hunting license. That does not erase probation terms, parole rules, protective orders, or state weapon restrictions. Before you buy, carry, store, or hunt with a crossbow, make 4 checks. First, check federal law. Crossbows are usually not firearms under the federal definition, but that is only one place. Second, check state and local law. Look for rules about felons, dangerous weapons, hunting weapons, carrying, storage, and transport. Third, check your court and supervision paperwork. Review probation, parole, supervised release, bond conditions, protective orders, and sentencing terms. Fourth, check hunting regulations. Confirm the season, license, tags, land rules, equipment standards, and transport rules before you go hunting. The best practical question is simple. With my conviction and my current status, can I legally possess, transport, store, or hunt with a crossbow? Ask your supervising officer, defense attorney, re-entry legal clinic, or state wildlife agency. When possible, get the answer in writing. So, can a felon own a crossbow? Under the federal firearm rule, a person with a felony is usually not automatically banned from owning a crossbow because crossbows usually are not firearms. But that is not the full answer. State law, local rules, probation, parole, supervised release, court orders, and hunting regulations can still make it illegal or risky. If your freedom is on the line, do not guess. Do not assume a store selling it means you can legally possess it. Do not assume a hunting license overrides felony restrictions or supervision conditions. Check your paperwork, check your state rules. Ask someone official before buying, carrying, storing, or hunting with a crossbow. If this helped clear things up, like this video and subscribe to Fresh Start Society. For more information and practical reentry resources, visit freshstartsocietyhq.com.